So welcome, welcome to the third session in our 2026 Underwriting Essentials series. These training sessions will explore the underwriting fundamentals relevant to practitioners across all classes of business. I'm Priya, I'm a Senior Underwriting and Claims Executive at the IUA. In case you haven't come across the IUA before, we're a trade association for the company market in London. We represent over 80 insurers and reinsurers. We run committees across almost all classes of business, bringing together practitioners to discuss common issues and to promote good practice. Next slide, please, Andrew.
Yes. Oh.
So before we get into today's session, this is just an opportunity to highlight a number of upcoming IUA events. We'll send across these details after the event, and you can also find them on the IUA website or via regular updates on LinkedIn. I've placed in bold the upcoming events in this Underwriting Essentials series. Just in case you have missed any of our events in this series, our remote training sessions are normally found on the IUA's YouTube channel. Next slide, please, Andrew. So, claims made v losses occurring. These fundamental concepts lay the foundations for insurance policies across all classes of business, and understanding the distinction is key. So that's the purpose of our session today. And finally, just a few admin points to note. We'll set aside some time for questions at the end of the session. Hopefully you spotted the Q&A function within the platform. We'll also circulate the slides, and we are recording this session. To lead today's sessions, we've secured the expertise of Andrew Schutte. He's the head of reinsurance at Keoghs and a partner. So I'll head over to Andrew and let him take the lead.
Thank you, Priya. Good afternoon, everybody. Welcome. Right, let's see if we can get going. So today's topic, we're going to spend an hour talking about losses occurring, occurrence-based policies, and claims-made policies. We are calling these the apple and pears of the insurance market. For those of you who haven't met me before, I'm Andrew Schutte. As Priya said, I'm a partner at Keoghs. Think of me if you have any coverage matters, if you've got supply chain issues. So I do things with MGAs and cover holders and reinsurers. Priya said, I'm head of reinsurance, do wordings, and I do a bit of training like this. Those of you who were at the last session I did within this series will know that I have a problem with having my phone stolen by my 4-year-old daughter. This means that I get quite literally thousands of selfies of my 4-year-old on my phone, which is a pain, which if you were at the last session, you would have seen the product of. Anyway, you'll be pleased to hear, if you're joining us again, that I have taken a strict line on this and imposed some community service on our resident criminal. She's been asked to produce all of the jokes, visual jokes, for today's session. So, yeah, that was a decent consequence, I think, for this constant phone theft. But I have to warn you, the results are mixed. They're mixed. You're going to see. Anyway, so you've been forewarned. The quality is patchy. Anyway, let's get going. So, losses occurring and claims made. So what are we talking about here? Yeah. Do you see what I mean? I mean, silly is the word I would use. Anyway, so we're going to talk about losses occurring where the trigger for cover is the loss or the event or the incident that occurs during the policy period. And that is one type of cover that you get in the market. And then the other, silly, again, claims made is the sort of cover where the trigger is the claim that is made by a third party against our policyholder, against the insured during the policy period. So, you've got 55 more minutes of those two different flavors. But actually, before we get into that, I do want to say that that is not absolutely the only way that you can structure your policy cover. There are some variants out there For example, it's not too bad, that one. If we were talking reinsurance, frequently you wouldn't have losses occurring or claims made, although you can have losses occurring on particularly property reinsurance. But frequently you find that it's risks attaching. So it's the risks that get written during the policy period that are the subject matter of the reinsurance. And that works quite well. I quite like risks attaching as my formula for generating cover under reinsurance. Yeah, I don't like so much losses occurring on risks attaching if it appears in that form. You see that in reinsurance. Don't love that one. Losses occurring during the policy period on risks attaching during the policy period? Question mark? Or is it losses occurring just on the risks that attach during the policy period? Anyway, we could go down a rabbit hole there. So I don't love that one. And one that we see increasingly frequently, but it's a cyber thing really, is a discovery trigger. So the incident gets discovered, which is understandable in some ways for cyber cover, but it can give rise. The reason we've still got the tangerine with a unhappy expression is because it can give rise to some evidential questions about when the discovery gets actually takes place. So anyway, and there are other variants out there, but I'm just saying it's not only apples and pears. There are other fruit, but we're going to focus on losses occurring in claims made, obviously. So let's dive into the first of those types of cover. Loss event incident occurring. If you go to the insuring clause, so that's the bit at the beginning of the policy that says something like, in consideration of the premium, blah, 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 we provide the insurance. If we had losses occurring cover, this is the sort of thing that we would see right there. So insurers agree to cover the insured against risks of loss occurring during the period of insurance. Unlikely to be with a pair with eyes on, but that's pretty much what you are looking for if you take that out. So as my kids would say, this is the OG. This is the original way of structuring your cover. And for a long time, this was the way in which insurance was written across the board. And it's still the way that insurance is written across what we call first-party insurance. I'm going to explain in the next slide what I mean by first-party and third-party insurance. So if you're not sure, hold on to that. But basically, property and other things, it's standard, losses occurring cover. And you also still see it in a type of third-party insurance. Well, two types, EL and PL, employer's liability and public liability. Still see it in those. So it's still very, very much part of the landscape, and it always has been. And one of the reasons for that, maybe the main reason for that, is it's intuitive. It's reasonably easy to understand. The insurers are going to cover bad things, what happened during the period. Stuff that occurs during the period causing loss, that is covered. So there's a lot to recommend losses occurring. There's a lot to like about that arrangement. Now, I said I would explain first party and third party. Here's a table that sort of shows you what I'm talking about. But in very simplistic terms, first party insurance is where we cover the policyholder for losses that they themselves suffer. And it's normally damage to their assets, fundamentally. Things that they own get damaged or stolen or lost, and we cover those. So property is the paradigm example. Construction all risks, in fact, anything that's got the words all risks, it's probably first party, maybe with a few add-ons that could be third party, but it's mainly first party. Terrorism is normally a subset of property, although you can get terrorism liability, like T3L wording, for instance, but normally that's first party. Hull and machinery, these are all things you can touch. They're all things that the policyholder owns. Marine cargo is the same. Something you can't touch but still falls into the first party bracket is business interruption, or if it was construction or risk, it would be delay in startup. So losses that arise as a result of normally physical damage, but it could be non-physical damage like COVID, let's just say. Losses that arise as a result of an insured peril or some other trigger. And they're all for the insured's own account. That's how come they fall into the first party bucket. Third party business or liability business, they mean the same thing. I mean, I think first party and third party is like an Americanism, really. But used a lot over here. Third party or liability business, that is where, simplistically, we are insuring the policyholder against being sued. We'll pay for your lawyers. If you have to pay out damages, we pay that, subject to terms and conditions. And there's a whole load of lines of business like that, listed. Some of the main ones here, D&O, FI, PI, EL, PL products. And then you get crossover lines of business. So examples of that would be cyber, where, for example, cyber BI, right, that's first party. You're insuring the insured against their own loss coming out of the trigger, the cyber event, security breach, whatever it might be. But you're also normally providing third-party cover for in case the insured gets sued by a data subject whose data they've lost, for example. And then with motor, if I ding my car, that's first party. If I ding someone else's car, they can sue me, and that's third party. And so on, and so on. So that's first party and third party. And basically, occurrence-based wordings are first party plus EL and PL, and everything else is claims made. It's normally the way that it works. And cyber and motor, those hybrid things, are a bit of a special case. But I want to focus in, to start with, losses occurring, that's where we are, and property losses in particular. So question arises, when does the loss occur? And obviously that's an important question if that's the cover that you're going to provide. When does the loss occur? And Mr. Justice, well, Lord Justice Popplewell, he is now, Andrew Popplewell, reminded us quite recently that at least under English law, there's a sort of funny fiction at work, an impossible promise, if you like, because we're not actually promising that if something gets damaged, we will repair it. What we're actually promising as insurers, we're promising that the policyholder, the assured, is not going to suffer damage, which is not really in our gift. We can't promise them that. But that's the fiction, that's the impossible promise. And then the way this works is, under the contract, the moment that the damage occurs, the damage that we promised wouldn't happen, we're in breach of that promise, and the insured has a right to sue us. So the bad thing happens, and the right to sue the insurer that has been insured against, that arises at the same moment as the occurrence. So how does that work, for instance, when we're looking at the cover that we're providing being eroded? Well, it's another way to look at it, and we need to ask ourselves, when does the right to an indemnity arise? And it's beautifully simple for losses occurring or occurrence-based business. When does the first party loss occur? It's the date of the fire, the flood, the earthquake. So what I was saying at the beginning, thousands upon thousands of these on my phone. My photo stream is nothing but these pictures, as you would have seen if you were at the last session. I don't know what to say. Anyway, so the fire, the flood, the earthquake, it's super simple. It's just whenever that happens, that's the occurrence. It's also when the insurer becomes liable to pay. Business interruption, as we've already seen, is normally part of many, not all, first party lines of business. And that's a bit of a special case. Losses occurring. Business interruption. Why? Because on the date of the flood, the fire, the earthquake, or the subsidence, whatever the peril might be, there isn't actually any business interruption loss. You're expecting that if the factory is burned down, there's going to be loss, and sure enough, there probably will be, but on that day one, you haven't actually suffered any loss. So there's two ways of looking at this. The business interruption loss could occur day by day, or indeed hour by hour, or minute by minute over the indemnity period. I mean, that would actually be in step with the reality. That's actually what's happening. Or maybe we need to introduce another fiction. We've already had The Impossible Promise from Andrew Popplewell. We can introduce another fiction, might be a bit more convenient, and say, we will deem that the business interruption loss, delay in startup loss, whatever it is going to occur on the date that the cover got triggered, which would be the date of the fire, the flood, the earthquake. And we've been debating that in the market for a long, long time until, under English law, we got the answer a few years ago now. It's the date, unless the policy wording says different, by the way, it's the date on which the cover gets triggered. So we're looking for the trigger date, and then we pop the BI loss in as occurring and indemnifiable on that date, even though the loss hasn't yet occurred and neither we or the policyholder has any idea what the final number is going to be. So that can produce some interesting consequences in real life. If I show you a very straightforward tower of cover, we've got a million retention and then 2 layers. It's all in the ag. Let's just imagine we have a policyholder who has a really bad year, and it pans out like this. So on the first day of the year, there's a fire A. There's a month worth of waiting period on the business interruption claim, so they can't claim for any losses in the first month. And there is quite a big interruption to the business, 6 months of outage as a result of fire A, so they can claim for 5 months of that. On the 1st of June, another fire. I said it was a bad year. First month, they can't claim for any BI there. It's a shorter period of outage, but there is some outage over 2 months. They've got a month's worth of BI cover. 1st of October, the insurer gets around to paying the property damage loss for the first fire, just short of $1 million, $750,000 they pay. 1st of November, the insurer pays out on the whole of the fire B claims, the PD and the BI, $3 million in all gets paid at once on the 1st of November. And right at the end of the year, the insurer works out what it wants to do on the BI loss for that fire that happened right at the beginning of the year and pays out $6 million. So how's our cover getting eroded? Well, we determine that according to the date on which the right to indemnity arose. And it is quite simple, really, because 1st of Jan, we get our fire A, it's within the ag, but it's eroding the tower. And the BI claim, even though it was paid at the end of the year, also attaches back to the 1st of January. The second fire, you'll remember, happened on the 1st of June. So that happens, and we pin the BI claim for that, even though it rolled out over the next 2 months, back to that 1st June date. And that's the way, subject to policy wording, that it would work. And you can see from that that it is a little bit weird in the sense that it's only on the 31st of December that we actually get to a final number for that biggest chunk of loss, actually, in green. But it attaches back to 1st January. If different considerations, let's say, apply to fire A and fire B, maybe they exceed the overall limits, and then you've got different reinsurance for fire A and fire B because they happen in different territories. It could be any number of things. Then this can get a little bit more fun, but usually it's reasonably straightforward. So it's the OG. It's losses occurring. We're looking at the date of the flood, the fire, the earthquake, your tiny BI back to that date, and then you just apply it against the cover in date order. You might think that's not that simple, but it doesn't get simpler than that. That's what I can tell you. So I think I'm being quite positive about losses occurring, and I like it. But that's not the way that it works across the market, although it once was. There has been a change. There's been a change, especially for liability business. But why? And to illustrate that, I need to show you a timeline. So we're going to show you how this pans out if you've got third-party cover. So here we got our timeline stretching over a few years. Bad thing happens here, event or the incident. And it's 2 years before any claim is issued against the insured. The insured might not know that this claim is coming down the track. They might know about the event or incident. They might think that was all water under the bridge. 2 years later, claim gets issued. Under English law, normally there's a 6-year limitation period. So year 2, they're actually not doing too bad. It could be a lot longer. And in some circumstances, limitation doesn't apply at all. So it could be a very long time indeed. And then, well, lawyers get involved. So obviously things go slow. And the insured pays the claim a couple of years later. So the problem for insurers with all of this is the insured's paying in year 4. But at the end of year, well, when we get to year 1, let's say, so let's say it's a year's policy, most of them are, policy expires, the insurer has no way of knowing that later on they're going to have to pay something. They've got no reserve, they've got no means of having the information they need to post a reserve. This all comes as an unwelcome surprise. And if you've been doing this for any length of time, you will know that one thing that insurers do not like to do is have reserves that are way different from their actual liabilities. It's super unpopular with the actuaries and everybody else. It's expensive. So this is not a great situation. It has given us an unwelcome tale. Mixed. I said before, it was mixed. An unwelcome tale. I suppose it is an unwelcome tale, isn't it? Yeah. So this has caused the industry quite a lot of problems over the years because, like I say, once upon a time, everything was losses occurring, occurrence-based. And most famously, of course, with asbestos. So in the early 20th century, people used to do a lot of building work with stuff called asbestos. It's fire retardant. It's easily shaped. It's quite useful. It looks quite useful, but it's got one really bad property, which is that little fibers of asbestos can go into your lungs and cause a horrible thing called mesothelioma, which will kill people. And at the time that people were breathing in asbestos dust, it wasn't known by insurers or anyone else that later on, many years later, there would be a wave of mesothelioma claims. So that sent a lot of insurance companies under because they were not reserved. They had not planned for this fortuity. They didn't know this was coming down the track. And that led to losses occurring, becoming quite unpopular in the liability space because of the long tail. So solutions had to be found. Well, you can reduce the risk of getting whacked with a long tail in the policy wordings. You can put in what are sometimes called sunset clauses. So you can say, we'll cover you for anything that happens as a result of bad things that occur in this policy period, but not forever and ever and ever, only for the next 5 years, let's say. And if nothing comes out of the woodwork within 5 years, well, then we're off. Sunset clauses. So that's one way of doing it. You can also back that up by saying, when you come on risk, oh, and if there was something bad that happened that's later going to produce a claim, we can exclude it. Although that's not super popular with policyholders. And generally, you've kind of fiddled around the edges with these solutions, but you have not really got to where insurers want to be, which is having a good line of sight to how much they need to set aside to pay out for their liability at the end of the policy year. There's only really one way of doing that, and that is claims-made cover. And that's how it was developed. So let's move on to the second. I mean, we started with the pears, didn't we? Weirdly. Anyway, now we're on to the apples. Claims made, the other type of cover. So if you were looking in your insuring clause and you were looking, oh, it says claims made, this is the sort of language you'd see. Insurers will indemnify the insured against any claim first made and notified during the policy period. Pausing there, there is a little wordings wrinkle to be aware of in any claims made cover, which is we use the word claim in two ways in this market. We talk about a policyholder making a claim on the insurance, making a claim to be indemnified by the insurers. That's one way we use the word claim. And we also use the word claim to signify claims that a third party will make against our policyholder. And when we write third-party business or liability business, they're the same thing. That's what we're insuring against, obviously. But we use the same word. So that creates a problem for drafters of claims made policies. Here, you can see that the word claim has got a capital C. And that's because it's defined elsewhere, and it's defined to mean claims that a third party makes against our policyholders. So if there's one of those comes along and it's notified during the policy period, then the insurers cover it. Yeah. This must have been the teenager. Anyway, so features of claims made. We're covering claims made by a third party against the insured and notified during the policy period. Fundamentally, that's what we're doing. The good thing about this is because it's got to be notified during the policy period, at the end of the period, you as the insurer should know how many claims or circumstances that could become claims. Now, just hold on to that expression. Hold that in your mind. We're going to come back to it in a minute. It is important. We're going to know how many things that could be a problem for us there are for our insured, and so for us. How many claims or possible future claims are there? That should all have been notified to us by the end of the policy period so we can set a reserve. It's actually quite tough sometimes to set a reserve because what's notified, I mean, how much is it going to cost? You come to a lawyer, we'll give you a view. A lawyer's always right. Little secret, no. So the idea anyway is that you can reserve properly and avoid a long tail. It's not always that easy, but that is putting you in the best possible position to do that. That's what claims made cover is for. So I said we talk about circumstances, and we will. We're going to start now. So what we're covering under claims made cover fundamentally is claims that are made by a third party against the insured, against the policyholder during the policy period and notified to insurers. So we're covering claims made during the policy period, hence the name. But we are also covering claims that are made against the insured after the policy period if they arise from circumstances first known or discovered and reported to insurers by the insured during the policy period. And that language about the circumstances is really important, and little changes can make a big difference. But the thing I want you to get at this point, before we go into all of those nuances, is we're covering claims made during the policy period, but we are also covering claims that may be made after the policy period if they arise from things that happened, could give rise to a claim, or knowledge at least that there could be things that gave rise to a claim that has been notified validly within the policy period. So it's claims made in the policy period and later if they satisfy all of the little criteria that we've got here on the second piece of text on the screen. And I'm going to unpack that in more detail in a minute. But first of all, let's define our terms on what a claim is, because clues in the title, we're covering claims made during the policy period. What is a claim, Andrew? I'm going to tell you. Well, first of all, check the wording, because the wording may well define claim. A popular definition would be this one. So it's a demand or an assertion of a right to basically money off the insured. You've done a bad thing, now you've got to pay me. Civil compensation or civil damages. Or I'm going to sue you, an intention to seek compensation by a third party against the insured. That's popular formula. In fact, it is the formula used in Novitas loans at AmTrust, which has only just come out. That's a case about litigation funders. And it's got a whole load of stuff in there about solicitors PI, if you're interested. Anyway, that's the definition used there. And it's more or less in line with the common law definition of a claim. So if there is no definition, we still normally think that assertion of a right is a good working rule of thumb for what a claim means. Remember, a claim by a third party against the policyholder, not a claim by the policyholder under the insurance policy for indemnity. Different thing. An essential feature of a claim, this assertion of a right or a demand, is that it has to be communicated. It can't just be somebody angrily sounding off in the mirror like Travis Bickle. It's got to be communicated from one person to another. So, as Lord Justice Staunton said, the ordinary meaning of the words claims made means that there's been a communication by the third party who wants to make the claim to the insured that they're not happy, that may result in a remedy from that insured. There has to be communication. It could be oral, it could be written, but there has to be communication. Lord Justice Staunton bears no resemblance to that. Just say. So that's what a claim is. That's what a claim is. It has to be an assertion of a right, normally, and it has to be communicated. So what are these circumstances of which you speak? Well, the first thing to say is that when you're trying to identify a circumstance that could lead to a claim, if it's properly notified under the policy, such that we might cover it, trying to establish whether or not something is a notifiable circumstance, it's an objective, not a subjective test. So often, if a question arises, well, should that be notified as a circumstance? Was that a notifiable circumstance? A broker or a policyholder might say, well, whoever it is who's got responsibility for these things, risk manager, didn't think it was a circumstance. I mean, that's useful information, but it is not determinative. When a court looks at it, they're not going to say, oh, yeah, well, he didn't think it was. So that's okay. No. Unless the wording actually says it's a subjective test and it depends what the risk manager thinks. It's an objective test, not a subjective test. In other words, we look at all of the facts, we look at the wording, and we see what a reasonable person who won't look like that, but may be a judge or an arbitrator, looking through the lens of a reasonable person's eyes, or what they imagine a reasonable person to be, what they think of as being a circumstance. So, sorry, long-winded way to explain. It's an objective, not subjective test. And it's normally defined in the policy as circumstance. So what is it? In this case, thing that happened that may give rise to a claim in respect to civil liability, in other words, for damages. So that's what we're looking at, something that may give rise to a claim under that wording. Now, we know from HLB Kidson's that a circumstance can't just be a mere concern. Oh, I think I might have done something that wasn't great today. I'm worried. Maybe my client could sue me. This is not me, by the way. I'm just playing a role. No client would ever sue me, I'm sure. But there's got to be more than a mere concern, is the point that I'm making. There's got to be a substratum of underlying external fact. Oh, no, I'm a roofer and I put the wrong roof material in there. Oh, I forgot to waterproof it. That might be enough, something that may give rise to a claim. But just being a bit worried about something, oh, I wonder if that new roofing material really is as good as they say it is. That's not enough. It's never going to be enough. It's got to be more than a mere concern. But a very, very important thing to be focusing in when we are looking for this language and the wording is what we're talking about, and the subjunctive bits, so the may, the would, the could, the might, which may give rise to a claim, or which is likely to give rise to a claim, or which might give rise to a claim, or could give rise to a claim. These are all potentially subtly different things. I think may and might and could are probably about the same thing. But we have some judicial guidance on what these things mean. So Rothschild and Collier, circumstances that may give rise to a claim, that's when a claim is at least possible. It's a super low bar. May or might or could. Quite a low bar. And again, Kidson's, but this was the first instance decision. All that has to exist is a state of affairs from which the prospects of a claim, doesn't have to be a good claim, could be a bad claim, or a loss emerging in the future are real. They're not false, fanciful, or imaginary. So again, quite a low, but not fanciful, quite a low bar. We like a visual representation. So it's hard to give a percentage on this. It's not a science, but could, may or might, maybe around 20%. I mean, maybe less, like not fanciful, it's probably less than 20%. But it's somewhere around there. With likely, though, if it's something that's likely to give rise to a claim, well, we can be a lot more scientific about it. And we can say, we know that. We know what that is. It's more likely than not. So that's anything over 50%. Anything over 50%. An objective test, as I've already stressed, unless the wording says differently. But it's not whether the insured or the broker has a subjective belief that something is likely to give rise to a claim or may give rise to a claim. Wow, you spent a lot of time talking about circumstances. Why does it matter? Well, it matters because claims made cover it's like a sort of machine with various interlocking bits. And one important component is what's sometimes called the deeming provision. These words on the screen. So I know that there's 4 lines of it, but it's worth reading. So, and other variants are available, but this is reasonably standard. If during the policy period, the insured or the policyholder becomes aware of any circumstances, likely in this case, so it could be may or might, give rise to a claim and gives notice of that to the insurer, then any claim by a third party that's later made against the insured, which arises out of those notified circumstances, is deemed to be a claim made during the policy period, the deeming provision. So that's how we get to call it claims made during the policy period, even though this claim actually arises sometime later. But we do know something about it because the circumstances have been notified. So that deeming provision, or words like it, is an important part of the machinery that goes into a working claims made policy. It also means notifiable circumstances, in this case, circumstances likely to give rise to a claim, they are going to be covered if they later produce a claim. Any claim that comes along later, those are going to be covered. But circumstances that are not likely to give rise to a claim are not notifiable, and they don't trigger the same thing. So if somebody were to call up the claims team and say, oh, I've got something, I think I'm just worried about it. The client wasn't super happy about it. I put this roof in and they say they didn't like it. And I'm a bit concerned because I realized I didn't put the waterproofing in. But maybe I did. I've forgotten. Claims handler might well say, that is not enough to be likely to give rise to a claim. That sounds like you can't really remember what happened and you're a bit worried. It's not enough. It's not more than 50% likely to give rise to a claim. Come back to me once you have a notifiable circumstance. Come back to me. So you've got to make a call one way or the other.
Andrew, we've just had a question come in.
Yes.
So does the claim have to be communicated to the actual insurer, or is there any agency at play, for example, the insurer's legal representative, the insurance broker, or the lead insurer, where the insurer is a follow?
Well, that's a very good question. So when Lord Justice Staunton, when he said the claim's got to be communicated, he was referring to the claim that the third party makes against the insured. So that has got to be communicated. That there's got to be some correspondence or some discussion that crosses the line between the third party claimant and the insured. Now, what the question is asking is notification of the claim on the insurance contract, I think. And we're going to look at notification separately in a few slides' time. But it's a good question. The notification might be made to a number of different people, and what is valid notice is another of these important moving parts, these important components of claims made cover. So I will come back to that in a minute. But the communication, just in order to be a claim that is made, an assertion of a right, you actually have to do some asserting. You have to communicate it to the target. of your litigation. So where were we? I'll come back to this one. So why is all of this circumstance stuff important? It's important because circumstances validly notified are deemed, any claim that arises from them is deemed to be a claim that's made in our policy period. That does mean that when a notification comes in, the insurer has got to make a call. Is this actually notifiable under our particular wording? And it's good practice to be clear about that as soon as you can be, but it's not always easy. It may not be obvious. I can also illustrate the point with a timeline. In fact, it's probably easier to do that. So here we have the life cycle of a claim. Bad thing happens, the wrongful act, negligent act happens at the beginning. Then there is a letter to the insured warning of potential consequences. At least it's a communication. Yeah. So we've got that. We've got that covered if it's an assertion of a right. Then you have a letter to the insured asking for a discount on the bills, which is definitely an assertion of a right, provided that it's tying back to the wrongful act, the negligent act. You did a bad thing, so I don't have to pay you. Then you have a letter of claim, a letter before action that goes to the insured from the third-party claimant. There's no outbreak of peace, so a claim form gets issued in the court. A deal is done with the third-party claimant, between the insured and the third-party claimant, and then right at the end, the insurer pays the claim. So that's a sort of life cycle of the risk. We need to pick out of that what is a claim and what is a circumstance. This is the assertion of a right in most cases, because why don't I have to pay your bills in full? It's because you were negligent and you've let me down. So I'm going to say you owe me money just as much as I owe you money. So I'm going to set it off. So that would normally be an assertion of a right. This letter here could be the assertion of a right. It really depends on what the letter says. If it's not the assertion of a right, if it's not a claim, it's also, well, it's very likely to be circumstances that are likely to give rise to a claim because it's warning of potential consequences. The suggestion there is that, we can sue you. So that would be probably circumstances. It could be the claim itself. The occurrence, if we had been on occurrence wording, but we've moved on from that, we're on claims made wording, is probably this bit here, the actual wrongful act. And in some cases, the wrongful act will also be the circumstances. Somebody falls on your premises, they break their leg, they say to you, I'm going to sue you. Well, you've got everything right there. You've got the occurrence, you've got the circumstance, you've got the claim. It's all right there. So it might all happen right at the same time. But let's just say, for the purpose of this illustration, that we've got circumstances, notifiable circumstances with the first letter, and then you've got a claim that gets made in the second letter. And let's also say that the policy periods fall as I've shown in this diagram. So the circumstances arise in policy period 1. Let's say those are notified. And the claim arises in policy period 2. So the way this would normally work is that this claim and all of the costs and the indemnity that gets paid at the end, that all fixes back into policy period 1. That's the way it should work. Now, if you change the periods, it does look different. So it's all quite sensitive to the timeline. In this slightly rearranged sequence, policy period 1 has come to an end before you get to the circumstances and the claim both fall within policy period 2. So happy days for whoever it was who was on policy period 1. They are no longer in the frame. It's whoever's on policy period 2 who's going to pick this up. And although bad stuff, well, not bad stuff, but the consequences are playing out over policy period 3 and afterwards, none of those insurers are involved. It's all going to be with policy period 2. Now, you might think to yourself, hold on, keep coming back to this idea, it's claims made. So the claim was actually made in policy period 2. Policy period 1 is picking, the answer to that question is yes, policy period 1 is going to pick it up on the this example that I've given. But why wouldn't policy period 2 as well? It's made in that period. And the answer is another essential working part of this claims made structure. So claims made machine. The known circumstances clause or the prior knowledge clause, it's called various things. And this one here, we've got circs that could give rise to a liability which were known or ought reasonably to have been known to the insured before the policy period, or anything notified to a prior year. So in our little example, actually B would apply, because I said that there was a notification of the circumstance to policy period 1. So policy period 2 has got this in. There's no cover because of the exclusion. But even if it hadn't been notified on this particular wording, it's probably the case that policy period 2 wouldn't pick up, because anything that was known or ought reasonably to be been known to the insured prior to the policy period isn't covered. And remember, we've got that letter threatening consequences and expressing dissatisfaction. So that might well be circumstances within A. So insurer on policy period 2 isn't picking that up in all likelihood. So that has the effect, that exclusion has the effect of allowing you as a liability underwriter to take each risk more or less clean from the day that the risk insets. There are variations of this clause. So on this one, this is a D&O exclusion. This is just going back and excluding facts that are the same or the related wrongful acts alleged or contained in any circumstance or insured event where notice has been given under a prior policy. So it's just, that bit there is just the B. There isn't an equivalent exactly of an A there. So it's more generous cover in that respect. Then it goes on to do some other things which we don't need to dwell on. This brings us to the black hole. So you need to, as a broker in this market, you need to try to make sure that nothing falls between the gaps between 1 year and another. Maybe you're getting the sense that is a reasonably technical exercise at times. And the thing you really got to watch out for is the black hole, as it's sometimes called. And I can show you how that works again visually. So policy period 1, you have an insured who notifies something that may give rise to a claim. But that is not what this policy requires. This policy says notify circumstances that are likely to give rise to a claim. So the claims handler says, well, that's all very interesting, but you can't actually notify that yet. It hasn't got that bad. It's a may give rise to a claim, maybe 20% chance, but it is not yet over 50%. So come back after it gets above 50%, if that ever happens. In policy period 2, and this normally comes up when there's a different insurer involved, the insured tries to notify exactly the same thing, which has got worse. It is now likely to give rise to a claim. And that insurer looks at their policy, they flick through, they see the prior circumstance exclusion, and they say, hold on, you notified this to last year. So we don't cover it. And they might also go on to say, oh, and by the way, you should have told us about this in the prop form, and you never did. You've got a duty of fair presentation. You should have told us all about it, and you didn't. If they didn't. So that is a problem. That is a problem for your insured. And it's a tricky situation. I mean, you might say that even if you are the same insurer in policy period 2, you've got the point that it was notified to a prior year. And if you've got the right exclusionary language, that might apply to the claim as presented in policy period 2. But that point is rarely run. So you need to watch out and make sure that everything ties together. The notifications that have been made and the cover that has been bought all needs to avoid a situation where a claim falls through the cracks. And there's various ways you can do that. A common way is to provide some sort of retroactive date so that a new insurer coming on cover actually does give some leeway for things from the past to come into their policy year. You can make sure that the terms fit together nice and neatly. You could ask a lawyer to help you, who knows? So that brings us then to notifications, which is the subject matter of the sensible question that got asked. Because notification, as we've seen already, is another really important component of this overall scheme that creates our claims made cover, which allows us to at least make a decent stab at reserving at the end of the year. because it's claims made and notified, or circumstances notified, that are the trigger for cover, because we want all the notifications in by the end of the policy period so we can do that reserving exercise. First of all, who is becoming aware of the thing that needs to be notified? Well, you might find some language about that, not always. This is another D&O example. The risk manager or general counsel has to become aware of the claim, and that's then the trigger to notify. If there's nothing in there, then it's the insured as a whole, probably. But sometimes whose awareness is important. And this was, I think, the question that's being asked. Who should be notified? Well, you need to check the wording. You might need to check other things as well. You might need to check your TOBA with the broker, because sometimes the broker will accept wordings on your behalf. You might have to check your agency agreement, your binding authority agreement with or a delegated claims agreement with a MGA or a TPA that's handling claims for you. It could be the lead. Could be a law firm. Sometimes a law firm sits in the position of being a TPA effectively, and the notification should go there. If the lead gets notified, then what should happen from there will be determined by whether SCAP applies, the subscription agreement, which bureau you're in. See the previous one of these sessions that we did for a bit more detail. You can look in the claims agreement practices for the IUA position on what a lead has got to do, but it's really going to be down to what happens on the Velonetic system. Probably. Quite often in this line, or these lines, claims made, liability business, you find that the underwriters find out about stuff that's going on at renewal negotiations, and it is a fact that quite a few notifications get made towards the end of a policy period to try to avoid a situation where new insurers come on and then stuff comes out of the woodwork, creating the sorts of problems that we've just been looking at. One question which comes up reasonably often is whether, if the underwriter's told that there's some problem out there, whether that's enough. The claims team might not know. And conversely, you can find, when you're looking at duty of fair presentation questions, the claims team know about a possible problem, they know about circumstances, but the underwriter doesn't. Don't expect a court or tribunal to be very sympathetic if you say, well, the left hand and the right hand don't always hear one another. Notification to anyone within your organization is probably going to be enough, no matter what the wording says, even if it's got a specific email address. There can be exceptions, but prudent approach would be to assume that wherever the notification goes within your organization, you're deemed to know about it. And if you've got a tower of cover, it may not be the case that the notification provisions are the same all the way up the tower. So if there's any brokers on the call, something to watch out for. Excess layers can have their own notification provisions. Make sure that everyone gets properly notified. What do you have to do at notification? Well, there's a bit of a theme here, isn't there? Check the wording. Check the wording. Often, not always, there's quite a lot of language in there that explains what needs to happen. Usually, if there's been an actual claim, you will need to attach the docket or the claim form or whatever and send that to whomever it is that you need to send it to. That might be the insurer, the TPA, the law firm, etc., the broker sometimes. Doing that as an agent of the underwriters, that can happen. Circumstances, what should you do? Have we got a likely? Have we got a may? If you think that we have a if the insured thinks that they've got a notifiable circumstance, we as the insurers would normally quite like an explanation about why it's notifiable, because that will help us to establish whether or not it's a valid notification. The wording may or may not address that. The insured will, even if we've got a may, which remember is a very low bar, they'll need to demonstrate that we're not talking about something that's remote, fanciful, or speculative, to go back to the Kidson's test. So we're going to apply that rule against it. And usually in writing, it's not a great idea, again, very brokers on the call, not usually a great idea to notify orally, and it's not usually done. Emails are good thing, I would say. And then you've got the question of when to notify. Here you get a sort of spectrum of possibilities. The language might start off looking something like this, and then you're looking for these sorts of variations. For some reason, I've coded these from a sort of policyholder perspective. I don't know why. But anyway, as soon as possible, I guess soon as possible is reasonably loose. What is possible is an actual question. So if it's around Christmas time or something, then you might find that the insured gets quite a long time to notify. Immediately probably isn't like this second. Courts aren't going to be that stringent about it, but it is a bit tighter than as soon as possible. My personal favorite, a hard number, a certain number of days. That is pretty clear. But then we've also got another selection to make, not just this sort of language, but also, importantly, we've got to decide, is this just a bare condition of the policy, just a regular term, or is it, to use the magic words, a condition precedent to liability? If it is a condition precedent, then that's important. If it's not, then all we can do is claim damages for breach of contract, and you have to show prejudice. It can be tricky. But if it's a condition precedent to notify within 14 days and the insured doesn't, there's no liability for the claim at all. Still good law, not popular law, but still good law. Most recently in this Muse restaurant case, lots of cases show that to be the case. So very important to know how hardcore your notification clause is. It's actually quite good. Well done, kid. And I said that we do erosion of limits for this as well. So I know we're coming towards the end of our time. But the question is really, when is a third-party claim indemnifiable? It's not the date of the fire, the flood, the earthquake. Oh, my God. It's the date of the settlement, the judgment, or the award, fundamentally. But in the case of defence costs, that is a horrible image. It's as they are incurred. It's the date on which they're incurred. So to give you another bad year, here we go. I will be quick. Here we've got a whole series of claims being notified, defence costs being incurred, and then settlements. And unlike with the losses occurring, we don't tie things back. What we do is the defence costs erode cover and are indemnifiable on the date on which they, probably on which they get billed, to be realistic, but it might be the day on which they get incurred. And then the settlement sums erode the cover, or the awards or the judgments erode the cover as they happen. So that can be a lot more complicated than on losses occurring, is the point that I'm making as I run out of time. So that does bring us to the end. What I want to say in summary is losses occurring or occurrence-based cover is still standard in first-party business, and you see it in EL and PL. It has the big merit of being readily understood, but watch out for business interruption. When you've got third-party insurance, you're probably looking at claims made. That is now market standard, and that's to limit the tail. There are all these different interlocking parts to claims made cover, and I've tried to walk you through the various bits that need to fit together. It should make a sort of scheme. It should make a coherent scheme. Caution is required at renewal. When insurers change in particular, that's when problems can arise, and watch out for notification of claims and circumstances. And I'm going to leave you with the one image on my phone, which is giving my wife nightmares, and I had to share it with you. What is that? God, I hope it didn't give you nightmares. These slides will be circulated. They've got links. And that's the end. 4 o'clock.
Thanks, Andrew, and thank you to everyone for joining today's session. We hope to see you all at the next session.